Hey guys, today we're going to talk about appointment of executors under your will. Now, what is an executor? An executor is someone that you trust, that you appoint under your will to carry out your wishes after you die. Common duties of an executor would include making funeral arrangements and the cremation of your body. If you leave instructions in your will, what happens after you die, for example, Christian or Buddhist or Taoist funeral arrangements, your body be cremated, the ashes scattered into the sea or kept in a niche. After the funeral, the executor will take the will to a lawyer to obtain a grant of probate, which is essentially a court order to approve the will. You cannot just take the will to a bank or HDB or to the insurance and say, nah, can I have the money? Can you transfer the flat? They will not allow that. You need to get a grant of probate. You can watch the video on grant of probate below. So, the lawyer will then take the will to the court and then write to the banks and insurance agencies and compile a list of assets which is filed with the court and then sealed and stamped by the court. After the grant of probate is obtained, the executor would then go to the different banks to take out the money, close the bank account, will take the grant of probate to the insurance companies to take out the death benefits, the death payouts. He will go to HDB to either get permission to sell the flat or to transfer the flat to the name of the beneficiaries, or if it's a private property, he will go to the SLA. The executor also has to pay off the debts, for example, credit card debts, loans owed by the deceased, the dead person, before handing out the money to the beneficiaries. Now, the executor is commonly referred to in the will as an executor and trustee. It is usually the same person. The executor is the trustee, but there is a technical difference. The executor is the person who executes the will, in other words, do the funeral arrangements, go to the lawyer, get probate, go to the banks, the insurance, HDB, SLA. That's the job of the executor. Technically, the trustee is the person who holds the money on trust and then gives out the money. That's the job of the trustee. But in practice, they are usually the same person. If you have a trust clause in your will, which is basically you want the executor trustee to hold on to the money and give it out in installments, or to hold it on behalf of children until they reach a certain age, for example, 21 years old, 25 years old, then the trustee will be the one giving out the money. So basically, it's just a technical difference. How many executors should you appoint in your will? Well, you should appoint at least one, but you should preferably appoint two or even more. You can appoint 2, 3, or 4 executors. Because what if the first executor dies before you, or is in a coma, or he simply doesn't feel like doing it? So you have to have a backup, a second layer, a third or fourth executor. Now, who can be your executor? Anyone above 21 years old, and is usually the biggest beneficiary under your will. So, for example, if your will states that you're going to give 40% to your brother, 40% to your best friend Peter, it will be logical to appoint your brother and Peter to be the executors, number 1 and number 2. Why? Because they're getting the most money. And the job of an executor is very troublesome, very leceh. So it makes sense to appoint the people getting the most money to do the work. Sometimes people don't want the beneficiaries, the people getting the money, to be executors because of trust issues or for whatever personal reasons. So they will appoint a friend or a colleague or someone that they trust. I've came across people who appoint the insurance agents. In such cases, when you appoint someone who is not getting anything under the will, it is customary, it is common to give them a small token sum for all the trouble. It could be 10,000, 20,000, even 5,000. You can also choose to appoint a professional executor to carry out your wishes under the will. This could be a lawyer in a law firm or a trust company licensed by the Monetary Authority of Singapore. Now, In your will, the appointment of executor clause, it is preferable to appoint executors in order of preference. That means you should say something like, I appoint A as my executor, but if he dies, then I appoint, if he dies or gets coma or doesn't want to do, then I appoint B. If B dies or coma, then C. C dies, coma, then D. Some people request that they appoint joint executors under a will. That means joint means both executors must act jointly. They have to do everything jointly. You need to take into account the practical considerations. They have to go to the lawyer together. They have to sign documents together. They have to take leave together to go to the bank, to go to HDB, to go to the real estate agent to sign things, to go to the insurance companies. It may not be practicable. It may not be practical because, you know, it may be difficult for two of them to take leave, to synchronize their leave arrangement together to go to all these parties. So after the executor goes to the banks, insurance companies, CDP, HDB, SLA to withdraw these monies, the checks, all the banks and insurance companies would usually issue a check to the estate of the deceased. So the check will actually state something like, the check issued by the bank or the insurance company would state, the estate of Peter Tan. The executor would then have to open an estate account with the bank. That means a dead person's account. He would then collect all these checks issued in the estate name, the estate of Peter Tan, throw it into the estate account, so there's a collective pool of money, and then from there he would have to write a check in the checkbook to the beneficiaries stated in the will, the amount of money. So for example, if the will states, I gave 100,000 to my mother, then he will write a check in the mother's name for 100,000 and give it to the mother. If the will states, I gave 20% of my assets to my sister Josephine, then the executor has to calculate the total amount of money in the estate bank account and then multiply it by 20% and then write the amount to the sister Josephine. If there is a trust clause for the executor and trustee to hold the monies on trust, for example, on behalf of young children until they reach a certain age, and then the trustee is allowed to give up money only for educational, living or medical expenses, then the executor and trustee would leave the money in the estate account, and whenever the child needs money for education or living expenses or medical expenses, he will write a check or TT the money to the child. And then if the trust clause in the will states that the monies will be given to the children when they reach the age of 25, so when they attain the age of 25, the executor will then write a check, the balance of the money in the estate account to the children. So thanks for watching this video on appointment of executors.